Hello friends, welcome to my channel Advocate Club. Today we have started a short review of Transfer of Property Act 1882. The total section content in this act is 1 to section 137. It came into force on 1st of July 1882. And overall spectrum of the Transfer of Property Act we have seen in this video, and this act is non-exhaustive and it is not applicable to Punjab and Muslim law. So on this we can revise a Transfer of Property Act only main questions, main sections, which is very important for preliminary examination for revision of every competitive examination. So do not waste any further more time. We can start the Transfer of Property Act section 1. Please friends, like, subscribe to my channel. So first chapter is preliminary chapter. It deals with content section 1 to section 4. Short title, interpretation clause. In interpretation clause there are some definition and it is a supplementary to Contract Act and Registration Act. Then our next chapter is the Transfer of Property Acts of Parties. Transfer of property by act of the parties. Inter-virus transfer in between living person happening in this chapter. So it is act between the parties. Parties must be living parties, inter-virus parties. Transfer of property whether movable or immovable. So merely the Transfer of Property Act deals with immovable property. Merely, not rarely. Most of chapter of Transfer of Property Act dealing with immovable property, and some of deal with movable property like gift. Some starting sections deal with movable property like section 5 to section 35 and so on. We can see further. First of section is Transfer of Property Act. Transfer of Property Act. Main essential element of Transfer of Property Act definition is first one, an act by act of the parties. It can be transfer the property or convey the property. Property convey present or future. It means property must be present property and conveys in present or future. Immovable, unmovable, both property convey in present or future, and the property must be a present property. Next one is a living person definition given under section 5. Living person means a company, corporation or association. Company, corporation or association. Living person includes these three words. It is also MCQ question friends, so you need to see. Thereafter we have seen what may be transfer. It means every exceptions, every general rule having an exceptions. The transfer of property is a general rule that every kind of property may be transferred. To this general rule, the section 6 is an exception. So some kind of property not to be transferred. The list given under section 6. Firstly, the section says that every kind of property, every description of property may be transferred except first one is a space successionist, next one is easement apart from dominant heritage, third one is right to re-entry, fourth feature of maintenance, 5 mere right to sue, not right to sue, public offices, salary, stipends and pensions. So on, this all list deals with the exception to this general rule. Such the pension properties cannot be transferred, so it is an exception. Next section is section 7, person competent to transfer. So competency of part transferor is necessary. Major, sound mind, not disqualified by law as mentioned in the Contract Act. And the second essential element of Section 7 is the person, agent, or it barely means that authorized person can be competent person and authorized person. Third essential element is wholly or partly transfer, or fourth one is absolutely or conditionally transfer. Absolutely and conditionally transfer. So this is the four essential element of section 7. Next one important section is section 9, oral transfer. Oral transfer, yes, oral transfer is in certain circumstances it is applicable. Movable property, if any immovable property more than 100 rupees it must be registered, and less than 100 rupees then it might be transferred without registration or orally transfer also applicable. So it is in circumstances oral transfer also available. Next section is section 10. Section 10, 11, 12 is a bunch of section. It is a restraining condition, restraining alienation. These are three conditions given under section 10, 11 and 12. First one is the condition on alienation. So here section 10, condition is void but transaction or transfer is valid. Same as restriction repugnant or to interest created. So enjoyment at interest, if condition on interest, it condition is void and transfer is valid. Same as section 12, the condition on transfer that interest determinable on the insolvency or attempt to alienation. When the party is when the transferee is insolvent, then the property may be revert back to original owner or transferor. Such kind of condition is void but the transfer is valid. Then after we have seen the another bunch of section 13, 14 and 17. We need to read this third three section column in together. So we have seen the general rule, transfer of property may be transferred in between living person. It means interstate transfer. But this general rule also another exception like transfer for the benefit of unborn person. Unborn person is not a living person, but the property may be transferred to unborn person on the condition that no direct transfer, prior interest must be created and absolute interest given to the unborn person. Then it is possible. The prior interest created to living person, an unborn person may acquire absolute interest at the time of upon his birth. It is also mentioned under section 20 of Transfer of Property Act. Upon his birth, he can take absolute interest, and prior interest must be created in favor of a living person. And in this section, section 13, there are two transfers. First one is a prior transfer, second one is an unborn transfer. So there are two transfer, and it is also called rule against double possibility. Then next section, section 14, deals with rule against perpetuity. Rule against perpetuity. So property must not be tied up for too long. Property cannot be tied up too long. It is a void. Cannot beyond the lifetime of living person. The living person's lifetime, the property can tie up, or age of the majority of unborn person. It means 18 year of the age, majority of the unborn person. You can tie up the property. Otherwise, you cannot tie up the property so long against perpetuity. Thereon, the exception to section 14 is section 18. Trust. Trust is a exception to section 14. So on our bunch, first, second and last one is a 17. Direction of accumulation. The direction of accumulation says that wholly or part accumulate for lifetime or 18 year, for lifetime of prior interest or 18 year of unborn person. So here also a lifetime or 18 year you can accumulate. But to this general rule, it has also given exception. The three exception to this general rule is, first one is exception. First one is payment of debt. If you have debt, then this payment to this debt, you can accumulate the property more than lifetime and 18 years of the minor person or unborn person. Next exception to section 17 is raising of portion of children, and third one is maintenance of the property. So for this three reason, you can accumulate more than lifetime or 18 year of unborn person, maintenance of property. So this is three exceptions to section 17. Thereon we have seen next section, the another bunch of three section is section 19, 20 and 21. It deals with vested interest, contingent interest. As we have already discussed, that section 20 deals with unborn person acquire vested interest upon his birth, transfer for his benefit. So thereafter we have seen the first bunch, the third bunch of first point, vested interest. Vested interest, it is a present fixed interest. It is a present fixed interest, and upon a happening certain event, upon happening a certain event, it can be transferable, and it is heritable, also attached in execution proceeding. This is the essential points for the section 19. And not defeated, right, are not defeated by the death of a transferee. If transferee died, there is no effect on this transaction because because ownership is transfer in vested interest, only possession on hold. Therefore, it is a present fixed interest. So the death of the transferee not defeated the right of a third person. Or if it is the transferee died, then the legal heirs is also acquire the right on that property not revert back to transferor or original owner. Next section, it deals with section 20, when unborn person acquire vested interest. It is upon his birth. He acquire vested interest. Next one is section 21. It is a contingent interest. Contingent interest, future possible interest. So it is a future possible interest. It is an uncertain event. It is happening or non-happening. Transferable and also non-heritable. Cannot be attached in execution proceeding. Execution proceeding. Further that, now we have seen section 25 onward, conditional transfer. We have seen in the bunch of three section 10, 11 and 12, the condition is void and the transfer is valid. But in section 25, the condition and also the transfer both are void. Conditional transfer is transfer and condition both are void. Why? Because if the condition is not fulfilled or it is unlawful, impossible, prohibited by law, unlawful, impossible, prohibited by law, or immoral, against public policy. I'm making short point. You can write down friend in detail if you wish. So fourth point is immoral, against public policy. Next one is injury to another person or property. So it is injuring the person or property. This kind of condition is condition and transfer both are void. Next section, which is important, section 29, I think section 26. 26 is a condition precedent. 26 condition precedent, and it is also called Sapper say. It is a question of prelim examination. Section 27, doctrine of acceleration. Okay, this section 27 deals with the doctrine of condition transfer to one person coupled with transfer to another on failure of prior disposition. So it is also called doctrine of acceleration. Next one is a section 29, condition subsequent ulterior disposition. Condition subsequent, it is dealt with ulterior disposition. It means prior disposition not affect the transfer. Next one is a section, important one is property not be ownerless. So it deals with section 23, transfer contingent on happening of a specific uncertain event. Why? Because it is specific purpose of section 23 is property not be ownerless. Thereafter we have seen concluded this 25-30 sections. Onwards we can jump to section 35. It deals with election when necessary. And what is the doctrine of election? It is based on equity, deal with movable and immovable both property. And also doctrine of election is property not his own by same transaction transfer from one person to another living person by express or implied. Okay, the property transfer by a person who is not a owner to another person for same transaction, then the owner of the property may elect or reject, the owner of the property A is a transferor, property not his own, the property is for some another person. He transfer the property by same transaction, then the owner has right to elect either express or by implied. If expressly he accept the transaction, then he can by words spoken or written. If expressly accept, and if impliedly, then the owner may enjoy the property. Implied acceptance, it must be by three type. First one is enjoy benefit for 2 year. He is enjoying benefit for 2 year. And next one is enjoy such manner cannot restore to original position. Third one is fails to elect for 1 year or reasonable time. Then that it is thinks that the owner is impliedly accepted this transfer. So the implied election or express election, and the owner must be elect either assent or dissent. Next one is important section 41, or we can see 36 is also a apportionment. Apportionment is a transfer. The doctrine of apportionment, it means a distribution of rent. Periodical payment and determination of interest of person entitled. Who is interested? Entitled the person, interest, entitled title. Then if he person entitled of interest determined on payment, then the distribution of rent is necessary. So on, next section is section 37, doctrine of contribution. It specifically says that doctrine of contribution. Okay. So you need to only remember this doctrine of contribution. So on, we have seen the second part, transfer of immovable property. So section 1 to section 37 onward, dealing with movable and immovable property, both kind of property, but onward section 38, we have seen only immovable property. Since we have seen immovable property, just section next is important for us, that is a section 41, transfer by ostensible owner. The ostensible owner means look like a owner. He can transfer the property, immovable property, for consideration, and it is not voidable. It means it is valid. Free consent and in good faith. If owner transfer ostensible owner, it means look like owner, who is a not real owner but it look like owner, he can transfer property. It is a valid in Transfer of Property Act. Next one is section 43, transfer by unauthorized person who subsequently acquire interest in the property transferred. So if unauthorized person who is not authorized to transfer the property subsequently acquire interest in such property, then he is binding by estoppel. As we know, estoppel deal in section 115 to 117 of Indian Evidence Act to stop the person or bind the person from for earlier words on of their earlier words. If he says something and subsequently he acquired the right on this property, then he need to transfer the property. It is also called doctrine of feeding the grant by estoppel. The subsequent acquirement of property, immovable property, operate against transferring. It is operate against transferring. Against transferring. Okay. Then after, the important section is section 44, transfer by co-owner. Transfer by co-owner is valid. Okay. Transfer by co-owner is valid. And transferee acquire all the right. If co-owner is transfer the property, then transferee acquire all the right in the property. The general rule, it is also having one exception, and the exception is dwelling house. Exception is dwelling house. Okay. Section 45 deals with joint transfer. It is also applicable and valid. Section 48 deals with priority of right created by transfer. Doctrine of priority. It is also called doctrine of priority, and it is used in redemption section 60. Onward we have seen. In redemption it can use doctrine of priority. So on, we have seen the next important section, transfer of property pending suit relating thereto. It is also called lease pendens. Suit pending in competent court. But if suit is pending in competent court, then it cannot be transferred from one person to another person. To this general rule, it is an exception if court permits that, or after that permission, the transferor transfer the property to third person, and the judgment or order by the honorable court is binding on the transferee. If it is a prior permission to transfer, then this transfer or but the judgment or the order of the honorable court is binding on transferee. But it is most important that it is not collusive suit, non-collusive suit, non-collusive suit, and it is for immovable property. As we have seen now, all the property is a immovable kind of property, so it is also immovable property. So further, transfer with court permission, and the question is directly in question. The property is in directly in question. Next section important is section 53. It is a fraudulent transfer. Fraudulent transfer is for immovable property. Also, it is for immovable property, and fraudulent transfer is voidable. It is not void or valid. It is voidable. The question arising on this point, it is a voidable transaction, and it is at the option of creditor. Voidable at the option of creditor. It is also important question for framing. Sorry, creditor. I am highlighting only important point which is important for MCQ examination, and it is also Benami transaction. Then onwards, section 53A, it is a part performance. Part performance is a contract in written and registered. First condition of part performance is it is written and registered. Next one point is it is also an immovable property. As we have seen after section 37, all the property are immovable properties, dealing with immovable property. So possession of transferee protected. In part performance, the possession of whose protected possession? The possession of transferee is protected. Is protected. And ready and willing to pay is important term for this section. Ready and willingness, and it is based on equity. Ready and willingness. It is based on equity. So, as we have seen, in Transfer of Property Act, there has been total 137 sections. Apart from that, section 53A, it is dealt with general transfers. Moreover, the second or the third chapter of sale onwards, mortgage, lease, exchange, gift, such kind of all the transfers are special transfer. Today we have seen an important or essential element of the sections on general transfers to section 1 to 53A. For today, it is sufficient. On our next video, we can see further the special transfers and important essential element for the examination point of view. What is the main crux of the sections of Transfer of Property Act? We can deal in our next lecture. Thanks for watching, friends. Best of luck for your examination. Have a nice day. Bye bye.